In 2020, something didn't add up. When fear replaced common sense and critical thinking, and protocols stopped matching what we were seeing, a lot of us started asking questions. And once you start digging, once you start researching, you can't unsee it. Welcome to Nurses Out Loud. I'm Jodi O'Malley, ER nurse and nursing ethics educator. And this is where we talk truth, patient rights, and real-world healthcare so you can make informed decisions and advocate with confidence. If you've been looking for your people, here we are. If this resonates, if you find yourself nodding along, please like, follow, and share this show with at least one person who needs it. And if this episode offers continuing education credit, check the show notes for learning objectives, disclosures, and exactly how to earn your certificate. This episode of Nurses Out Loud is sponsored by West Cocoa Pharmacy in Cocoa, Florida. If you've been looking for a pharmacy that thinks outside the one-size-fits-all box, West Cocoa Pharmacy partners with licensed prescribers to create individualized prescription-only compounded medications. That includes ivermectin, benbendazole, fenbendazole, and other repurposed drugs, alike low-dose naltrexone, methylene blue, bioidentical hormone replacement therapy, custom erectile dysfunction combinations for men, and carefully selected supplements. They also support integrative oncology care, offering compounded medications that some physicians use in alternative cancer protocols. One of my favorite parts is their free consult with Nurse Donna. She's there to provide education on evolving repurposed therapies and HRT, so you can ask better questions and have a more informed conversation with your own clinician. As always, this is not medical advice. I'm not telling you what to take. I'm pointing you to resources. Any medication or protocol should be decided between you and a licensed provider who knows your history. To learn more, visit Cocoa Pharmacy, COCOA Pharmacy.com. That's Cocoa Pharmacy, COCOA Pharmacy.com, and let them know you heard about them on Nurses Out Loud. Today's episode matters, not just as a parent issue, not just as a legal issue, but as an ethics issue that nurses are uniquely positioned to understand. Because after 2020, we watched how quickly policy can become coercion, how fast dissent gets labeled as danger, and how institutions can punish people who refuse to comply. What you're about to hear is an excerpt from attorney Ryan Heath's podcast, where he breaks down a case called GW versus Coronado Unified School District. Coronado High School is on Coronado Island in San Diego, California, and this case centers on a teenage girl who peacefully protested a government school policy. Here's what should stop you in your tracks. After the family sued, the school district is attempting to collect $104,090.07 from the child and her mother. That number isn't symbolic. It's the kind of financial threat that teaches ordinary people, don't challenge the government, don't challenge institutions, don't speak up because the cost is too high. Now, quick ground rules before we start. Everything you're about to hear today is educational and grounded in public court filings and records. This episode is not legal advice. It's a breakdown of how civil liberties and due process can get twisted, and why that matters for professionals who are called to advocate, even when it's uncomfortable. And a quick disclosure here, Ryan Heath has served as my attorney in an unrelated matter. I am not compensated for sharing his content. You will hear a call to support the organization, the Gavel Project. Donations are voluntary, tax deductible, and no portion benefits me. And yes, I'm packaging this as a continuing nursing education episode because the topic connects directly to professional ethics, advocacy, moral courage, and the chilling effect that retaliation has on truth-telling. In our new 2025 Code of Ethics, it also calls for nurses to support whistleblowers, which is new from the previous one 10 years ago. When people learn that speaking up is financially dangerous, they stop speaking up. And that impacts patients, families, and society. One more thing. Ryan also spoke publicly at Coronado Unified School District meeting in 2021 about this, and I'm going to include the links in the show notes and my Substack article for anyone who wants additional context. You don't have to watch those videos to understand today's episode, but they provide helpful background. So here's how we'll do this. I'm going to play Ryan's breakdown in 3 short blocks. And after each block, I'll pause and give you my commentary from a nurse's lens and a parent lens. So it's clear why this precedent matters far beyond one school district. All right, guys, let's go. You're about to hear attorney Ryan Heath explain why he believes it's better to use a gavel than a gun, and why the cost of dissent could become a price tag only the wealthy can afford.
I'm Ryan Heath. Welcome to Saving Gen Alpha. This show exists for one reason, because it's better to use a gavel than a gun. And I mean that literally. When people lose faith that the courts can protect them, when they learn that peaceful legal action can ruin them financially, something replaces the gavel. And whatever replaces it, it is never civilized. Today's episode is about a case that most Americans have never heard of, but that may become one of the most dangerous civil rights precedents in modern American history. GW, the Coronado Unified School District. This case is about a teenage girl who protested a government policy. She tried to stand her ground peacefully. She tried to use the system. And now a government school district is trying to collect over $100,000 from her and her family. That number isn't symbolic. It's real. It's enforceable. And it's the kind of debt that destroys lives. Everything we're about to discuss is grounded in public court records and filings, including the emergency stay application now being prepared for the U.S. Supreme Court. This episode is educational. It's not legal advice, but it's also a warning. So let's start with the human story. In early 2022, actually starting back in the beginning of 2021 school year, Coronado High School required students to wear masks indoors. GW was a student, and in January of 2022, after 6 months of suffering and being unable to breathe freely in class, she began to come to school without a mask, intentionally, as a protest. She wasn't screaming, she wasn't violent, she wasn't threatening anyone. She was, by all accounts, doing the most American thing possible, peacefully dissenting. And here's what happened next. Instead of letting her sit in class while they handled the issues through normal discipline, instead of dealing with a perfectly healthy child who did not have COVID-19 like a typical school would, the adults did something that should disturb every parent in America. They alienated her. Not just socially, not just emotionally, but physically. They forced her for 6 weeks to sit outside the classroom doors in the freezing cold, in the scorching heat. They made her participate from the hallway, from random corners of campus via Zoom. Often she wasn't even allowed to access her class. And if you've never thought about what it means for a teenager, let me paint a picture. You're 15 or 16 years old. You're already self-conscious. You're already trying to survive socially. You already feel like the world is watching you. And now you're being treated like a biohazard, like a leper. The filings describe GW as being excluded from instruction, made to endure cold and heat, and subjected to humiliating treatment by the people who were supposed to be caring for her. And then came the moment that, as a parent, makes my blood run cold. During an emergency lockdown drill, because GW didn't want to wear a mask like her sheepish classmates, she wasn't allowed to lock down with them. Instead, she was instructed to shelter in a nearby bathroom, one that didn't have an interior lock on the door. Let me translate that in plain English. In the event of an active shooter, which is what this drill was for, the school's solution was simple. You don't get to have the same protection as everyone else. If that doesn't make you angry, I don't know what will. This perfectly healthy child who did not have COVID-19 and was not disrupting her classmates, all she did was go into class, peacefully take her mask off, and sit down.
All right, pause right there. If you're a parent listening, I want you to feel what you just heard in your body for a second, because this isn't abstract. It's not a policy memo. It's a teenager being treated like she's contaminating the air, like she's a threat because she dissented. And I'm going to say this as a nurse. Institutional humiliation is never neutral. When adults with authority isolate someone publicly, when they force them to sit outside a classroom door, participate from a hallway, participate from random corners of campus, or get pushed onto Zoom while everyone else is inside, that is not education. That is a social and psychological punishment. Now, I want to highlight the piece that hit me in the gut, the lockdown drill, because at that moment, it's not even about mask anymore. It's about whether a child is entitled to basic protection. If the drill is meant to prepare for an active shooter, if the purpose is, how do we protect students? And the solution is, you go to a bathroom that doesn't lock, what you're communicating is, your safety is conditional. Your dignity is conditional. Your belonging is conditional. And nurses recognize this pattern because we watched it happen in healthcare too. When systems start operating from fear, they create categories: compliant, non-compliant, safe, unsafe, good, and bad. And once you get put into the bad category, everything that happens to you gets justified as your fault. Let me connect this to why I'm even airing this. I pulled my own son out of school during the mask era. I watched adults treat children like problems to manage instead of human beings to protect. And I remember the moment my son came home and said, they put a mask on me and I couldn't breathe and I have a headache. That was the day I decided, you're not going back. I'm homeschooling because I'm not going to have my child trained into fear and compliance by a system that won't even listen when his body is telling him something is wrong. Now, I made masks. I went to the store and I made masks that he could breathe in. But one teacher had an emotional outburst in the middle of when he was changing class in the 5th grade and was like, you, go to the office now. You can't be wearing that mask. And that's when they slapped surgical mask on him. And I was livid. So listen, guys, whether you agree with GW's protest or not, I want you to listen carefully, because the issue is not whether you personally would have worn a mask. The issue is what happens when a government institution responds to dissent by isolating, humiliating, and endangering a child, and then acts shocked when the family seeks accountability. That's what we're tracking here. How quickly coercion becomes normalized, and how quickly people learn that speaking up just costs too much. All right, let's keep going, because Ryan is about to explain something most people have never even heard of: anti-SLAPP.
When they asked her to put it on, she just said no thank you. She was suspended twice for this. She was threatened with discipline repeatedly, and she was marked as unexcused. The school district threatened to file truancy charges against her mom. After several months of abuse, GW was completely at a loss. So she disenrolled. In August of 2022, GW and her mother, Nicole Ward, with the help of the Gavel Project, filed a lawsuit claiming civil rights violations and other claims. And here's the key point. This case was not simply about whether masks work. We know they don't. We knew then that they didn't work. Masking has never worked to slow a respiratory virus in the history of humankind. We knew that at the time. There's not a single credible scientific study backing up the mask mandates that were forced down our throats by our government. This case is about whether the government can respond to peaceful dissent with coercion, humiliation, and exclusion. Because in America, even if the government thinks you're wrong, you're still allowed to dissent. At least that's what the First Amendment stands for. Now I have to teach you about something that most Americans have never heard of. It's called Anti-SLAPP. SLAPP, spelled with 2 P's, stands for Strategic Lawsuits Against Public Participation. Anti-SLAPP laws, which exist in the majority of states across this country, were created to protect citizens. Here's the classic scenario. A powerful person gets mad that you spoke up publicly about what they're doing. So they sue you, not because they expect to win, but because they want to ruin you financially. They want to bankrupt you. So anti-SLAPP is supposed to stop that. The anti-SLAPP process works very specifically according to the statute. You actually have to follow, as a court, a 2-part test before you can dismiss a case. And the first step is on the defendants. It is their burden to prove that the lawsuit, the reason they were sued, is because they were engaged in protected speech or petitioning activity. Meaning, you sued me because I spoke publicly about an issue of social concern. In other words, anti-SLAPP applies when you sue someone for furthering the public discourse on an issue impacting our society. And here's the huge part. If the defendant wins, the plaintiff must pay their attorney's fees. It's mandatory. That means anti-SLAPP isn't just dismissal, it's punishment for filing a suit to vindicate your rights. Now let me explain anti-SLAPP with an analogy that you'll never forget. Imagine this. You are a regular person. Your city is dumping chemicals in the water. So you sue the city, and you show up to court, and the city says, your lawsuit is attacking our protected activity because we held meetings and passed a policy months ago that allowed us to dump these chemicals into the water. And the judge says, case dismissed. And the city says, also, you owe us $100,000 for our lawyers. That's what anti-SLAPP becomes when it's misused. A statute meant to protect the public from powerful bullies turns into a weapon for powerful institutions to financially destroy the public and shut down dissenting viewpoints. In this case, the defendants filed 4 anti-SLAPP motions claiming that punishing a child, aka child abuse, to shut down her dissenting viewpoint was free speech. The trial court granted all 4 motions, and the Court of Appeal affirmed. At the same time, however, the Court of Appeal explained something that should make every American's jaw drop. The appellate court admitted it couldn't even properly assess the first step in the analysis without a proper factual summary of what each defendant allegedly did and said. And instead of reversing, because that was not in the record, it blamed the plaintiffs for not providing what the defendants were required to provide. That's the inversion. The statute explicitly requires the defendants to identify which of their statements and actions were protected activity. And to date, they haven't done so. And no court has explained how shutting down a dissenting viewpoint to enforce a government policy that pre-existed the protest was protected speech. Instead, the court shifted their burden onto the plaintiffs. That's not just unfair, that's due process destroyed. Now we have to talk about the May 2023 hearing, because this is where the public needs to understand something very clearly. This did not look like neutral judging. It looked like a court picking a predetermined outcome. During the hearing, the judge compared GW's unmasked presence, while perfectly healthy, to bringing a gun to school. I'm going to quote the court. "Guns kill, and so does COVID," end quote. Sit with that. Because that statement alone tells you how the judge framed this case. Not as student protest, not as a constitutional question, not as a civil rights dispute, but as a public danger. And once a judge has decided that you are a danger, everything you do becomes a disruption. Everything you say becomes a threat. Everything you claim becomes frivolous. The judge repeatedly stated that he would take, quote, judicial notice, end quote, of disputed scientific facts, including the fact that GW was an asymptomatic carrier of COVID, even though she provided the court with a sworn declaration attesting to the opposite, and even though the court was required by law to accept her allegations and her sworn statements as true. That is not the mindset of a court carefully applying a statute. That is the mindset of a court justifying its predetermined outcome.
Okay, pause again, because this is the part where people's eyes glaze over, and I don't want that to happen. This is the core of why this case matters nationally. Ryan just explained anti-SLAPP, strategic lawsuits against public participation. And here's the simplest way to say it. Anti-SLAPP was created to stop powerful people and institutions from suing ordinary citizens into silence. So if someone speaks up on a matter of public concern and the powerful party sues them, not to win, but to bury them in legal fees, anti-SLAPP is supposed to shut that down quickly. But what Ryan is arguing is that in this case, it got flipped. And when you flip it, it becomes something terrifying. It becomes a mechanism where a citizen tries to hold an institution accountable, and the institution says, well, actually, you attacked our protected activity, and now you owe us a mountain of attorney's fees. That's the chilling effect. That's the deterrent. That's the warning label on dissent. Now, I want to say this, because people ask me, they're like, Jodi, what happens if you lose your whistleblower? You know, are you going to have to pay for HHS's attorney? And it's like, no, thank God. How many people you think would have spoken up if that's the case? I mean, shoot, it was hard enough to find an attorney to represent me. But I want to say this in a way that nurses will immediately understand. Process matters. In healthcare, we have policies and protocols. In nursing ethics, we have standards. But what protects people isn't just the existence of a policy, it's fair application of that policy. It's consistent burden. It's due process. And what you heard Ryan describe was a claimed inversion. The burden shifts away from the institution and lands on the individual. And once that happens, you're not dealing with an even playing field anymore. You're dealing with a system where the outcome is effectively predetermined. And then there's that judge's quote, guns kill, and so does COVID. Oh my God. What? That line matters because it shows the lens being used. Because once a judge frames a peaceful protest as equivalent to bringing a weapon, the person is no longer a citizen. They become a threat. And once you're labeled as a threat, everything is easy to justify. Nurses, you know that dynamic. We watched it happen when people questioned protocols, when families asked for second opinions, when colleagues raised safety concerns. The minute someone becomes a problem, the system stops listening. The system starts defending itself. And here's the professional takeaway. This doesn't just affect one family. This affects every nurse who advocates, every nurse who documents, and every nurse who questions a policy that harms patients. Because if the cultural lesson becomes you will pay for speaking up, then most people will stay quiet, even when they know something is wrong. So yes, this is a legal case, but it's also an ethics case. It's about whether institutions can punish dissent through humiliation on the front end and financial annihilation on the back end. There aren't many supplements I recommend, but I do believe we're supposed to steward our bodies well. And it's hard to do that when you're feeling exhausted. Green 85 helps me with my daily energy, making sure I get my vitamins and micronutrients. And V-Stack helps me get nutrients and vitamins without overthinking it. Go to chemicalfreebody.com/NOL. That's chemicalfreebody.com/NOL for a discount. All right, one more block because the final section is where he lays out symbolic speech and why the First Amendment could become a luxury item.
Now let's explain what it is that GW claimed when she said she was engaging in free speech, because that's what we were suing over. The First Amendment protects not just your words. It also protects actions that clearly communicate a message to a reasonable observer. This is called symbolic speech, and there are classic examples. For instance, wearing an armband, kneeling, burning a flag, wearing political clothing, refusing to participate in compelled rituals like standing up for the Pledge of Allegiance. Those are all protected activity because people seeing the refusal or seeing you engaging in that action understand what it is you were trying to say with your expressive conduct. So the question the court is supposed to ask is, would a reasonable observer understand the message based on the context? In this case, GW wasn't merely forgetting a mask. She was walking into class with one on and taking it off as a show of defiance. She did it intentionally, repeatedly, politely, as a form of protest. Every single one of her friends in that room knew it. And that's why the response escalated. Because it wasn't about fabric. It was about defiance. Think about it this way. Imagine that you walk into an airport today and you see someone in a mask. If they're not sick, they're wearing it for another reason. They're expressing a viewpoint with that article of clothing. You know which team they're on already, based on the fact they're wearing a mask in public. So here's the constitutional inversion. Anti-SLAPP is supposed to protect free speech. But here, anti-SLAPP was used to destroy the lives of individuals engaging in free speech. And even worse, the government's enforcement actions were treated as protected activity, meaning the government shutting down dissenting viewpoints became the thing protected, and disagreement became the thing punished. That is upside down. The First Amendment is supposed to protect citizens from government retaliation when they are engaged in free speech. It is not intended to protect government retaliation from citizen lawsuits. So here's where the punishment becomes real. The school district is attempting to collect over $100,000 from GW and her mother. And the Court of Appeal imposed a sanction on council of $13,000, plus state bar reporting consequences for pointing out the fact that the court dismissed this case without engaging in the first prong of the mandatory analysis. In other words, because the court acted without jurisdiction in excess of the explicit jurisdiction conferred by the anti-SLAPP statute, which requires the court to engage in a two-pronged inquiry which never happened, she was sanctioned for it. That's not just a slap on the wrist. It's financial annihilation. This is the government saying, if you sue us, we will ruin you. Now let's get to the real danger here. If the Supreme Court does not accept review, this becomes the lesson. Peaceful protest is allowed until the government disagrees and punishes you for speaking out. And if you sue us, it's going to cost you your future. And it gets worse because anti-SLAPP statutes exist in most states. If California's new approach spreads, the precedent becomes civil rights claims can be dismissed before discovery, government defendants can avoid their statutory burden, courts can treat enforcement as protected speech, and plaintiffs can be punished financially for petitioning their government for redress. It doesn't just chill free speech, it destroys it. You will no longer have the right to dissent if this precedent stands. And when citizens learn that courts are not safe, they stop going to court. They stop believing in the rule of law. And when the gavel fails, people reach for something else. That's how societies collapse. So right now, we submitted an emergency stay application on Wednesday electronically. That was February 4th, seeking to prevent enforcement while the Supreme Court review is pursued. The petition for certiorari, which we will be filing soon, is due by March 30th, 2026. So whether you agree with GW about masks is irrelevant. The question is, should the government be able to financially annihilate a family for suing to vindicate their constitutional rights? Do you have the right as a U.S. citizen to dissent peacefully from compelled conformity of thought? Or are you just a slave? If this case isn't overturned, the First Amendment becomes a luxury item. If you want to support this fight and help us fund our U.S. Supreme Court counsel, the Gavel Project is raising support now. You can support this case by making a tax-deductible donation on our website, thegavelproject.com. This case will decide whether peaceful dissent is still allowed in America. All right, and just an addendum to today's episode. I just want to make sure if anyone has any questions about this, I understand it's a complex legal issue. Put your questions in the comments below. I'll respond to those questions during the next episode. And this is part one of a two-part series. We're going to have Nicole Ward and Tracy Henderson fly out from California to join me here in Arizona at the beginning of March. And we will release the episode talking about how all of this happened, my interactions with the family during the protest, really the background story of this case. You'll get that in the part two to this series. So tune in then. Thanks.
All right, guys, let's land this. Ryan just walked you through symbolic speech and the inversion problem and why this could become a precedent that prices ordinary Americans out of their civil rights. And I want to give you 3 clean takeaways, especially if you're listening as a nurse. Takeaway 1, a right you can't afford to use is not a right. When the cost of petitioning your government for redress becomes 6 figures, most families will never do it. And that means the right exists on paper, but not in real life. Takeaway 2, retaliation doesn't have to be physical to be real. In this story, the punishment began socially and emotionally. Public isolation, exclusion, humiliation. And then it becomes financial. That arc should be recognizable to anyone who has ever tried to speak up in a broken system. The system rarely starts with, quote, we will ruin you. It starts with, quote, we will make you regret it. Takeaway 3, this is bigger than masks. You can hold your own opinion about COVID, politics, science, all of it. But the principle here is timeless. Can government institutions retaliate against dissent and then shield themselves from accountability? By procedural weapons. Because if the answer is yes, then dissent becomes theoretical. Now, I'm going to say something directly to nurses. After 2020, many of us learned the hard way that, quote, because we said so, is not enough. We learned that protocols can be wrong. We learned that institutions can close ranks. And we learned that moral courage costs something. But we also learned this: silence has a cost too. And if you're thinking, this isn't my fight, I want to challenge you. Because the moment you accept that a family can be financially annihilated for challenging a government school district, a public school district, you are accepting a precedent that will not stay confined to schools. This touches healthcare. This touches licensing boards. This touches whistleblowers. This touches professional advocacy. Because the first step in controlling people is teaching them that speaking up is unaffordable. So here's what you can do. First, share this episode and do it with your whole list. I would love that. I want to get some light on this case. But especially to at least one person who still believes institutions will always do the right thing when challenged. Second, if you believe citizens should be able to challenge the government without risking financial ruin, you can support the fight at thegavelproject.com. Donations are voluntary, tax deductible. And I'll repeat my disclosure. Ryan Heath has served as my attorney in an unrelated matter. I am not compensated for sharing this content, and no portion of donations benefits me. And for those of you listening for continuing nursing education, check the show notes for the learning objectives, post-test, and the evaluation when we publish the CE version. You can go to NursesOutLoud.com. Lastly, Ryan mentioned that part 2 is coming with GW's mother, Nicole Ward, and Tracy Henderson with the background story. With that, when that episode drops, we'll cover that too. And then hopefully I can get an interview with the two of them, because this isn't just about one case. This is a cultural moment. A gavel rather than a gun only works if courts remain a place where ordinary people can seek justice without being destroyed for trying. Follow Nurses Out Loud to get the CNE details and resources for this episode. Go to NursesOutLoud.com. And thanks for listening. I'll see you next time. Until then, friends, be safe, be well, and God bless. Thank you for listening to Nurses Out Loud. Nurses are called by our code of ethics to keep learning, do the research, and lead with moral courage and integrity, especially as healthcare changes. Keep doing the next right thing, especially when it's hard. If this show resonated with you, please like, share, and follow. It boosts us up in the algorithm so more people can find us. Until next time, friends, be safe, be well, and God bless. And if this episode offers continuing education credit, check the show notes for the learning objectives, disclosures, and exactly how to earn your certificate.